Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court. And now for our presentation. Thank you. The next issue we're going to address is that family court is obligated to demonstrate jurisdiction whenever it is raised. The judges like to ignore it and blow the litigants off. Even the appellate court and our illustrious Chief Judge Simmons and Kay were well involved in it. The court is obligated to specifically demonstrate that it has jurisdiction to enforce or modify any court order or agreement, or for any action that the court may take. People versus Kellerman. While jurisdiction of a court of general jurisdiction is presumed, that of a court of limited jurisdiction, the Ulster County Court must, same thing for the family court, whenever questioned, be specifically demonstrated. Although a court of record, it is a family court, is a court whose jurisdiction is limited to the powers set forth in the Constitution of the State of New York, Article 6, Section 13, which we've been discussing. Its jurisdiction will never be presumed, and the facts necessary to confer jurisdiction in any particular case must affirmatively appear in the record. It doesn't happen. Here is one of the biggest frauds family court is committing, and it's based upon a Supreme Court ruling back, well, these are some of the rulings first, then we'll get to that one. Family court has jurisdiction to determine custody of minors only when such jurisdiction is referred to it by the Supreme Court. They were divorced, you need a referral. Family court may not modify or enforce a divorce, separation, or annulment decree of the Supreme Court which provides for visitation or custody unless the decree specifically authorizes. Notice it says the decree specifically authorizes it. In other words, it has to be in the judgment of divorce. If the legislature intended to clothe family court with jurisdiction proceedings related to support of dependents in cases incidental to matrimonial actions, in other words, divorce, without a reference from the Supreme Court, its act would disregard the explicit provisions of the Constitution and abridge the jurisdiction of the Supreme Court. Right on point, exactly what I've been arguing. Now, family court does it all the time. You have a separation agreement. Guess what? Family court has no jurisdiction over your separation agreement. Kayla versus Kayla, 1980. And this has not been overturned by as far as I know, by the Court of Appeal. Family court is a court of limited jurisdiction which lacks the power to modify the terms of a separation agreement. They do it all the time. Support issues especially, they have no authority. as opposed to the terms of a divorce decree. They're separating. If it's just in the divorce decree, you need a referral. Even if there's a referral, family court doesn't have jurisdiction over separation agreements. Where parts of a separation agreement are incorporated but not merged within the decree, the separation contains in effect as a separate and independent contractual arrangement between the parties. Thus, a change in the divorce decree cannot modify the separation agreement absent a clear expression of the parties to such an intent. So every time family court has modified a separation agreement, it's illegal. And they've been doing it. This is one of my issues I've been raising since 1990, and this is the case I was relying on. Can't get any higher. Actions instituted in Handa versus Handa. Actions instituted to enforce the separation agreement as opposed to those seeking support within the meaning of the jurisdictional statutes and constitutional provision pertaining to the family court. Subject matter jurisdiction may not be conferred on the family court by the parties to the separation agreement. So even if you agreed to it, family court doesn't have the jurisdiction to do anything. Now, we were also talking about a referral from the Supreme Court if you just have a divorce decree as opposed to a separation agreement that's incorporated. You just have your decree, no separation agreement. And as it said in the state constitution, the matters must be referred to the family court. The referral must be specifically ordered in a decretal paragraph of the judgment of divorce. There is no decretal paragraph referring any issue of custody support to the family court from the Supreme Court. That was my divorce decree. I had a separation agreement. Family court had no authority to hear it. There was no decretal paragraph in the judgment of divorce. What they did was, in my case, this was the second appeal that I raised this issue. My attorney in the first one didn't raise this issue. I raised the issue of it wasn't there. They said because we had as an agreement that we could use family court. That's not a referral. Parties can't consent, as it was stated a minute ago, consent to the jurisdiction of where the court doesn't have it. They can't hear separation agreements. There was no decretal paragraph. Jesse versus Evans. The judgment did not contain a decretal paragraph referring applications to modify judgment as to support and custody to the family court. Jurisdiction of the family court cannot thereafter be invoked to award support unless the Supreme Court either referred the matter of support to the family court or petitioner is likely to become a public charge. I don't buy the second part, but again, the first part is right on point for what I'm arguing. It is undisputed the Supreme Court did not transfer the issue of support to the family court. Accordingly, the award of support is invalid, as the family court did not properly acquire jurisdiction. In any event, the parties were no longer husband and wife when the judgment of divorce was entered in the Supreme Court, and even if family court had jurisdiction theretofore, such jurisdiction would then have terminated. These are appellate court rulings. But the big thing, when you go to enforce or modify a court order, you have to go to CPLR 2221, motion affecting prior order. And the motion is very clear. A motion for leave to renew or to re-argue a prior motion, for leave to appeal or to stay, vacate, or to modify an order, which is what they're looking to do, shall be made on notice to the judge who signed the order. So you have to go back to the judge who signed the order, unless he is for any reason unable to hear it, except that if the order was made upon a default such motion to any judge of the court, If the order was made without notice, such motion may be made without notice to the judge who signed it or on notice to any other judge of the court. You have to go back to either the judge that signed it, but you have to go back to the Supreme Court. You just can't willy-nilly go into family court like they want you to do. So once you have a court order, unless there's a referral, and I'll tell you, I've been involved in this for 20-some years. Rarely have I seen a referral. The other thing that throws these into all these court orders out, and mine didn't have it, and none of the others do, Domestic Relations Law Section 251 states, when in a matrimonial action the Supreme Court refers the issue of support, custody, or visitation to the family court, the order or judgment shall. Shall means it is required. It's not an option. It's a requirement. Shall be filed by the plaintiff's attorney within 10 days with the clerk of the family court. This is to be required to be put in it. If it's not in there and they don't file it within the 10 days, family court can't acquire jurisdiction and they can't claim there's a referral because the New York State statute, domestic relations law, specifically states what they have to do to be able to transfer it. I will tell you, it's not in any of the court orders.